Welcome. Today we're going to be covering the Guide to Computer Forensics Investigations. This is the 6th edition. The material all comes from Cengage. They own and control all copyright material. I'm just providing video lectures on the individual chapters for my courses using this textbook. My name is Arthur Salmon, and I'm going to be working with you throughout this book. Thank you. Chapter 1 is all about understanding the digital forensics professional and investigation process. So with this, our main objectives are going to be describing the digital forensics field, explain how to prepare to become a digital forensics investigator. This material focuses predominantly on the computer side of digital forensics. We're going to be looking at the differences between the public sector and private sector forms of investigation. We're going to be looking at understanding professional conduct and how important it is to understand that reputation. We're going to describe how to prepare for a digital forensics investigation, looking at the systematic approach or the different phases for that approach. We're going to describe the procedure for private sector digital forensics. We do not get into public sector because that is typically law enforcement. So we're going to be covering the private sector path. We're going to examine the requirements for data recovery workstations and software at a very high level. We're going to summarize how to conduct that investigation, including critiquing a case so that we understand kind of that overall process. Alright, so what is digital forensics? Digital forensics is essentially the application of some form of digital science, computer science, and the investigative process for legal purposes. Normally that would include things like the analysis of digital evidence. That's also going to be understanding the structure of how digital evidence was collected, such as, did you have the proper authority? Was the documentation or the chain of custody appropriate? Was there a validation of some type of mathematical component or an algorithm that verified what you took from the assailant's electronic device was actually the same as what you were analyzing through hashes for validation? Is the process repeatable? Meaning, if I go to a case, I find an assailant's laptop, I clone it, I go to my workstation, I verified that everything is appropriate, and then I did my analysis. Can someone go behind me and repeat the same steps and find the same results? That is crucial for digital forensics. Part of this goes back into the report writing. If I followed the methodology and I documented it, I should be able to hand it off to a counterparty. Let's say I'm on the prosecutor's team. If I hand this to the defense, their expert, their analyst, should be able to follow the same steps and get the same results. Part of that is going to also be then the presentation of your findings as an expert presentation. In early 2012, the International Standard Organization did standardize for digital forensics the ISO 27037 information technology and security techniques specifically for digital forensics. Inside the US, we also have the Federal Rules of Evidence, and that was created to ensure consistency within all federal cases. This was in early 70s. While many states do have rules mapped to the Federal Rules of Evidence, there are state rules of evidence as well. You're going to be using the most stringent set of rules typically, and understand that while you are not the legal expert, you're going to be working as a team, and there's going to be some form of general counsel or lawyer involved on your side that's going to allow for following of the state's procedures that you are in. And again, if you're outside the US, you're going to be following whatever appropriate laws are for that area. Again, consulting with general counsel or legal counsel to verify you're following all of the appropriate rules of evidence so that you don't accidentally do something you're not supposed to. In the US, we also have the Computer Analysis and Response Team, CART. That was mid-80s, and that was done by the FBI, and that was specifically involving cases for digital evidence. By the late 90s, CART has actually teamed up with other departments so that you end up with like the Department of Defense Computer Forensics Laboratory, DCFL, as well. And early 2000s, they grew. In the mid-teens, 2000s, it grew as well. But those are the foundations of several of these. We also have amendments that we have to follow within the U.S. For example, the Fourth Amendment of the U.S. Constitution does protect everyone's right for secure forms of search and seizure, meaning, do you have the appropriate authority to search and seize material from a digital device? And that's going to be tied back to public versus private sector. If you're working for a business, for example, and the assets are owned by the business, are there policies in place for the seizure of the electronic assets from a worker? Again, every U.S. jurisdiction has case laws related to evidence admissions, such as recovered from a computer or a mobile phone or other electronic devices, what is allowed to be admissible into court. Again, working with general counsel or legal counsel, you have to follow the appropriate laws in your area while gathering evidence, because if you gather evidence incorrectly, it may not be admissible into court, and then this entire process would be mute. But you need to understand that within digital forensics, this is not just the only field. So when we're investigating digital devices or digital items, we're going to be looking at collecting data securely. That means collecting data in a secure manner that is appropriate to standards set forth by our government and by the industry. That also means examining suspected data to determine original and the content. That means also presenting the digital evidence, information, constructs to a legal body, typically a court. Also then applying the laws to digital device practices. While granted that may not be the individual digital forensics specialists or the analysts portion, but within their team, that is what they're going to be doing. Digital forensics is different from data recovery. Data recovery is all about being able to recover lost data, while digital forensics involve retrieving information that was deleted by purpose, or uncovering things that were hidden. Digital forensics is actually trying to understand what had occurred in the past following some type of event. Illegal content, whether it be illegal based off of the public sector or illegal based off of the private sector where that asset belongs. Data recovery specifically is retrieving accidentally deleted or mistakenly lost data because of something natural, not so much after something illegal was done. Yes, I understand that a server crash is not natural, but I mean like power loss or a user accidentally deleting things. The server crash, if not maintained, would then be natural for the server to crash. That's more along the lines of what I meant. Forensics investigations, again, they work part of a team. Normally the investigation triad. The investigator is only one part of it. We also have things like the network intrusion. We also have things like incident response. We also have vulnerability and threat assessment, risk management. And then we have the digital investigators. In reality, we have a few deeper levels than this, because within our legal realm, we have our legal realm, our general counsel, our legal counsel, and they often fall in terms of the digital investigation process. So under digital investigation, we may have a digital investigator, but we also may have a legal counsel individual. Within the other two realms, like vulnerability, threat assessment, and risk management, they're going to be testing and verifying the integrity of devices. The network intrusion and incident response, they're going to be looking for intruders on the network using tools as well as monitoring network traffic. Incident response definitely can fall in all of these areas. Digital investigation or digital forensics, often referred to as DFIR, will also have an incident response. Digital forensics and incident response, DFIR. And that is going to be the investigators, that's going to be everyone that's collecting evidence, that's going to also be the parties involved verifying that evidence is collected correctly. Alright, so let's talk about history. So essentially, computers have been around, as we know them, late 60s, early 70s, but a lot of people did not look at the crime or the digital crime that was occurring, and as it became more and more rapid, the government started realizing we need to do something about that. So, by the early 1990s, the International Association of Computer Investigator Specialists introduced some basic training on software for digital forensics. Before the 1990s, the groups existed, the software existed, but there really wasn't a lot of training that was out there. Also during this time frame, we had like the IRS, they did the search warrant program, the ASR did data creation for the expert witnesses for Macintosh. iLook is also currently maintained by the IRS criminal investigative divisions. We also then had open source software and other software developers start creating content. For example, FTK toolkits, Access Data Forensics Toolkits. Access Data makes FTK, and FTK is going to be one of the more popular commercial products out there. And when we get to the lab component of our course, we're going to be using FTK quite often to perform these labs. We had case law. So first of all, we need to understand what case law really means. So essentially, we have laws. So an existing law might take forever or might take years or 20 years or 5 years or even just a year to update. Well, technology changes quickly. So laws cannot keep up with the rate of change for technology. So when statutes don't exist, they create case law. Basically, this will allow legal counsel to apply previous similar cases, they have to be similar, to current ones in an effort to address any ambiguity within the laws currently in existence. Essentially, what ends up happening is, if we look at a case right now, if there's no law that's applicable, we'll look at similar cases for similar situations. If there was a similar situation, then we can apply the rulings from that case to our case in terms of the different precedents, the different allocations of resources, the different structure of that case. So examiners must be familiar with recent court rulings, especially on search and seizure, as well as search and seizure for electronic environments and electronic devices. And again, this may not be the overall examiner, this may be someone on the examiner's team, like legal counsel, that is familiar with it. So how do we develop our resources? How do we get on top of this? Well, normally, we have to have a way to supplement our knowledge. We're not always going to be reading journals. We're not always going to be reading what's current and involved. Experience is going to be our best friend, coupled with training, coupled with understanding that this field is always changing. So maybe not reading every single day, but we definitely need to keep abreast of what's going on. Conferences, or joining like a computer technology investigators network or meeting with other individuals in your area. Develop and maintain contacts within the investigation profession so that we can learn and grow from one another. So, when we're preparing for a digital investigation, there are two types of investigations, a public sector and a private sector. This becomes extremely important that we understand public versus private sector investigations. Public sector is very similar to government. That's going to be state, local, federal government. Whereas the private sector is going to be more businesses, corporations. The government agencies have things like the Fourth Amendment protecting for search and seizures. The private organizations have policy violations, as well as litigation disputes. Public sector is typically for the good of the public. The private sector is what's good for the business. Public sector involves, again, government agencies. They're the ones responsible for criminal investigations. We have things like the Fourth Amendment. We have things like the Department of Justice, where the private sector is more based off of policy violation for the organizations, not for government. Government is public. Private business is private sector. When we're looking at a public sector investigation, we have to understand laws for computer-related crimes. If we are doing a private sector investigation and we encounter something that is actually controlled by the public sector, we have to stop. We are not allowed. We do not have standing legal process. We do not have guidelines for search and seizure. We do not have the right or the ability to build a criminal case. That is public sector. So, with that in mind, it is crucial to understand when conducting a private investigation. For example, we are looking for material on a worker's laptop that might be in violation of the company's policy. We filed child porn. Instantly, we stop our investigation. Child porn is criminal. We stop our investigation. We escalate it to the appropriate governing body, the police, for example, and they take over the investigation because their investigation, public sector or criminal proceedings, trump our private sector investigations. The government also has things like the Computer Fraud and Abuse Act, which was passed in the mid-'80s. Basically, this is specific state laws. This was a federal law that just kind of gave the federal government overreaching. Then afterwards, specific state laws were developed for each of the individual states to kind of have their own flavor of it. Essentially, a criminal investigation will always begin with someone finding evidence of a crime. Could be a witness, could be some form of other evidence. It could be a person seeing something and then they go to the police. Well, in that case, that would mean the witness or the victim would make an allegation to the police. A statement, hey, this is something that happened. The police would interview the compliant or write a report or do something about the crime. They would start the investigation process. The report would be processed and managed, would decide how the investigation would proceed, or if they would just log the information in a police blotter. The blotter is basically a historical database for previous crimes, and they would determine how to proceed. The written report is part of the investigative process. That is going to be the foundation that begins the process. Very specific legal processes are going to be digital evidence, first responders. That's going to be the first responders that are on a scene that start collecting digital evidence. We also have a digital evidence specialist, a DES. They have these skills to analyze the data a little more in depth. Then we also have an affidavit. An affidavit is a sworn statement of support of facts about an evidence of a crime. Normally this has to be included in the exhibits that support an allegation. There is a very strict legal process that must be followed in order to take this allegation from the report process to court. Alright, so now that we understand the public sector, let's look at the private sector. The private sector, again, involves private companies. Typically, some companies will also have their own lawyers, their own general counsel, and things like that. They address policy violations as well as litigation disputes. Wrongful termination, for example, or you were looking at content that you weren't supposed to be, so you violated the acceptable use policy, or some other policy. Basically, businesses strive to minimize or to eliminate litigation the best they can. Private sector crime typically involves harassment through email, falsification of data, discrimination based off of a protected class, embezzlement, espionage, sabotage, or other forms of either industrial or corporate espionage. Those are all covered in the private sector section. Businesses basically reduce the risk of litigation by publishing and maintaining policies in a handbook, typically, that all organizational employees or stakeholders can read. They then have to follow them. The most important policy defines the rules for using the company's computer and network, typically referred to as the acceptable use policy. The big thing here is also understanding the concept of line of authority. Basically, this will state who has the legal right to initiate the investigation, who can take possession of evidence, and who can have access to that evidence. The big thing is the line of authority or the authority body. For example, for a public sector, the police have the line of authority or the proof of authority. They have the right to initiate the investigation. In the that's in the public sector. In the private sector, in the policies, there has to be a section that outlines who is the line of authority or who is the authoritative body that can start the investigation process. Because this process can't just be started by anyone. It has to be clearly outlined who is allowed to do it. Businesses can also avoid litigation by displaying things like a warning banner on the message on the computer screen as a message. Basically informs end users that the organization reserves the right to inspect computer systems and network traffic at will. Even if you don't recall that in the policy handbook, if there are warning banners, then that negates you having to read that handbook. If it's a government facility, same thing, you'd get a warning banner that basically prompts you to read through and understand before you're allowed to continue on. You have to accept those terms and services or TOSs. Alright, so for example, in the private industry, you might have things like use of this system and network is for official business only, or system network are subject to monitoring, or using this system implies consent by monitoring by the owner, or unauthorized or illegal use for the system will be subject to discipline or prosecution. Those are all nice examples. The big thing is your general counsel, the legal counsel, typically will write the statement that is then displayed. And that's going to be more of the IT cybersecurity route, not so much for the investigator, but the investigator does need to make sure that they have the legal authority to do the collection. Also, businesses need to advise to be specific for authorized requesters, basically who has the power to initiate the investigation. Again, this has to be outlined who's authorized. Examples might be corporate security investigation, ethics office, equal employment opportunity office, auditors, general counsel, legal department, could be HR. It really just depends on who specifically are authorized requesters. Again, it's not going to be willy-nilly. It's going to be clearly defined, typically by general counsel, who can initiate the process. We also have the process of the investigation within the private sector. Basically, you search for evidence that supports the allegation of the violation of the rules that you were presented with. You come in, HR says they have the legal authority, it's been verified, you are looking for X on this worker's computer. You have a scope. You then look for that scope. The scope will typically be defined based off of the reasoning or the situation. The situation could be like abuse or misuse of the asset, email or internet abuse. Those are common examples. So then you, the investigator, would have to process and search for those evidence. The private sector investigator's job is to basically to minimize the risk to the organization. But you also have to follow the scope set forth by the organization. If you are brought in to look for email abuse, you shouldn't be searching for Word documents. Your scope is going to be narrowed based off of the situation that you were brought in to investigate. The distinction between personal and company devices are becoming very blurred. Cell phones, smartphones, notebooks, tablets. The BYOD environment basically brings in a whole new set of headaches. If the company has personal devices allowed to connect to their network and they follow and they actually developed a policy, then you'd follow company rules. Oftentimes, the court has agreed that personal devices connected to the business network, while they are a personal device, still fall under the same rules as the company property asset, even though it's personal property. So, how do you get in, you've done this process, you're investigating. You, the investigator, also then have to have a certain level of professional conduct. You have to have a specific bar of ethical and moral rules as well as standard of behavior. You cannot do shady things if you're the one investigating everyone. That doesn't fly. The investigator must exhibit typically the highest level of professional behavior. That means they have to maintain objectivity. They must be credible. They must be able to maintain confidentiality. If your professional behavior is called into question, you probably would not be the investigator anymore. The investigator should also attend training to stay current with the latest technical, moral, ethical components, software, hardware, networking, and tools used in the industry. The reason I brought up things like moral and ethical components while talking about technical changes, mainly because if you go into an industry and you normally do things ABC, but the industry has found that ABC is morally questionable, well, you then would have to then adjust the way that you do your proceedings based off of those findings, meaning you have to be kept abreast of what's going on. The role of the forensics professional is to gather evidence to provide support of a submitted or alleged crime or violation of policy. However, you cannot ignore evidence that is against what you're trying to do. For example, I once had a case where I was investigating a worker for violating the acceptable use policy for checking personal email while on company time. His workstation logged into a Gmail account, for example, and that was the evidence I collected. I went further to find that during that time, that workstation, well, the person logging into that workstation prior to that individual happened to be a IT person. The IT person proceeded to change the password of that worker. That worker was out of the country on leave. Well, the evidence, if I was being subjective, I would have just stopped at, that user logged into the email. However, there was additional evidence to consider. One, the fact that the worker was out of the country. Two, the prior login was an IT admin who changed the password of that worker. That right there changed the narrative. It clearly could not have been that worker because it was shown to be an IT person who changed the password, as well as that person was out of the country. So collecting evidence has to be done in an unbiased manner. You will also be collecting evidence to be offered in court or corporate inquiries. Basically, you'd be investigating the alleged individual's electronic devices, and you need to preserve the evidence that is gathered. Part of that evidence must also be documented via chain of custody. That's going to be the routine that the evidence was gathered with. You go to a site, you collect evidence. Well, you collecting that evidence is documentation. You putting the hard drive of the computer or the cell phone into your possession, that's documentation. You taking that evidence to your workstation to be analyzed, again, documentation. All of that's going to be documentation in the form of a chain of custody. Who had access to that evidence when and throughout the entire life cycle. So now that we've talked about the investigative process, let's talk about the overview of a computer crime. Basically, a computer will contain information that will help law enforcement. That right there lets you know we're dealing with public or criminal proceedings. Part of this will be a chain of evidence leading to a crime, as well as the evidence that led to the conviction. If the chain of custody was not done correctly, then the chain of events leading to the crime would be called into question and could no longer be admissible into court. So the chain of evidence is extremely important, or the chain of custody of the evidence is extremely important. Law enforcement officers should also follow the appropriate policies and procedures for acquiring evidence. That's pretty straightforward. That is regardless if we're dealing with public or private sector. The investigator collecting evidence need to follow all of the policies, period. If you have an overeager investigator and they happen to alter data for some reason, it's inadmissible. There might be a legal precedent or there might be a case law that can be reviewed, but oftentimes if the investigator destroys or modifies evidence, it's no longer trustworthy, it's no longer admissible into court, it's done. For example, a potential challenge, information on a hard disk that's password protected. So the forensics tool may need to be used in your investigation to blank the password. Well, there are court cases showing the process that is allowed to do this. Changing the password would be modifying the evidence. In that regard, seek legal counsel. They will give you the appropriate process, and then you could proceed forward. That would be an appropriate case where tampering or modification of evidence would be acceptable as long as it's documented and as long as you follow the appropriate procedure. Failure to do so would then violate the protection of that evidence and again would no longer be admissible into court. So again, this covers computer crime, but this can be applied to both public and private sector. Again, if it's criminal, it's going to fall underneath public, period. If it's law enforcement doing it, it's public, period. But oftentimes, changing the password, for example, that could apply to both public and privates. chain of custody, both public and private. Alright, so now that we kind of looked at computer crime, let's look at violations of policies. So essentially, an employee going into an organization and misusing a company assets. Well, misuse could be surfing the internet, could be checking personal email, could be sending email, could be you sitting at the computer updating your resume on company time. Well, all of those could possibly be violations of the company's acceptable use policy. Again, every organization will have a separate acceptable use policy, so it is important that you understand those policies and you're looking specifically for a specific violation. That is why earlier in the example I said HR. HR typically understands their policies and typically have the authority to start an investigation. So if HR says, hey, we believe this person is violating this policy, go investigate. Well, they have the legal authority, they gave you your scope, and then they gave you the section of the policy that is thought to be in violation of. So, it doesn't matter public or private. We're going to be looking at the process. So how do we begin? Well, there's a systematic approach for the investigative process. Essentially, we treat it like solving a problem. We make the initial assessment about the type of case we're investigating. We determine the appropriate design. We check for detailed lists. Are there certain things that we have to do, certain things we're not allowed to do based off of the scope we have? We figure out the resources we may need. We get the resources. We obtain or do a copy of the digital evidence. From there, we use the appropriate tools to proceed. We would then identify the risk for obtaining the evidence. We would mitigate or minimize the risk as best possible. Would test our design. We would then analyze and recover any evidence. We'd investigate the data recovered. We would write a report, critique the case, and then modify as necessary. For example, a common question is, what do we mean by identify risk? Well, let's say we get called to do an investigation on a workstation that's currently powered on. Well, we don't know if there's disk encryption. We don't know if there's evidence in memory. So the ability to just power off the machine and clone the disk isn't necessarily going to be there. We may have to then think about, maybe first thing we need to do is capture our volatile memory. Also, we may have to do a live acquisition of the drive, because if we suspect there is drive encryption, power cycling the machine may make the drive inaccessible. And again, documenting the entire process as we go through it. So again, the systematic outline of the case would be based off of the situation, the specifics of the case, the type of evidence, known data, the disk types, disk encryption, as well as the location of the evidence. All of this is going to matter. That will help outline your approach. So based off of these, you can then determine the case requirements before you proceed. So once we have the basic requirements, we can start planning the investigation. So how do we acquire the data? How do we complete the evidence forms? How do we make sure we have an established chain of custody? How do we know how to take it from the crime scene to the lab? How do we worry about securing the evidence in an approved secure container or bags correctly? We don't often think about this because oftentimes when we're doing this, we are following our organization's structured policies and procedures for data collection, for chain of custody, for transportation. We, the individual, are not having to create these off of the fly. We are following our company's policies for acquiring the evidence, for transportation, for documentation, for chain of custody. These are things that we often don't worry about in terms of having to create. We have to only worry about following them as they are outlined by our organization. So part of the investigation would also be things like our forensics workstation. Where are we going to analyze the data? What software is on that workstation? Is that workstation appropriate? When we retrieve the evidence from a secured container, how do we get it from the secured container to our workstation? Is there a process? Is there documentation? How do we make sure that we have a copy of the data, not the original data? How can we verify the original data and our copy are identical? We do that through hashes, which we'll discuss later. The thing here is we're walking through the process so we understand what's involved. We also have forms. The fun part with this is forensics is very report and form driven. When we move the evidence from one location to another, well, there's a custody form. So generally there is two different forms of custody forms. There's going to be a single evidence or multi-evidence form. Single evidence is one piece, multi-evidence is multiple. Oftentimes these forms are also called a chain of custody or chain of evidence forms. The chain of custody would be if the evidence is going to be stored in a box, for example, and within the box there's multiple forms of digital evidence that are each individually marked as well. If the entire box is also claimed as evidence, then as we move the evidence, it could be a single or multi-evidence form. Here's an example of our form. It's really crappy photo, but it does show the case, it shows the investigation, the organization, the investigator, and it gives you details on being able to write notes. A single evidence form, again, crappy photo, but it shows you a little less information because we only have a single evidence in this regard. So now we have a good understanding of evidence, the chain of evidence, the paperwork. Now let's talk about securing the evidence. So you're on the site, you're working on a mobile device or a computer or whatever it may be. How do you store it? So normally there are evidence bags that are used to secure and catalog the evidence. If it's a mobile device, it may go into a Faraday type protected bag. It may go in a regular evidence bag. It really depends on the situation. If there are a concern about electronic or electrostatic discharge for the electronics, we may have like an anti-static bag or an anti-static pad that the evidence will go into. If we're dealing with something that is more sensitive, we may have a padded container. Evidence will be taped and sealed with all openings so that it cannot be accessed without removing of the tape. For example, like a CD drive bay will be taped and closed. Floppy drive bays, again, closed. The sides of the case, or assuming it's a computer, it'll all be taped and closed. That way nothing can be added or removed without violating that tape or without removing that tape. Any type of insertion slot for power supplies or USB cables, again, everything will be tagged. The initial evidence will be then signed off, normally with initials on the tape. So as you're taping the different components, you're actually adding your initials to it, thus verifying that you're the one that did it. That way, if someone removes the tape in transport and replaces the tape, well, the replacement tape shouldn't have your initials on them. So consider computer-specific temperature and humidity ranges as well. If you're collecting evidence and it's raining outside, for example, will the humidity or the water damage any of the evidence? If so, you have to make sure that you have certain precautions to take while transporting the evidence from the location to a transportation vehicle or from the transportation vehicle to the secured location. One of the big things when looking at this, oftentimes we forget that we are doing this as a team and we're doing this with an organization. You're not doing it alone. So, normally, there's going to be people that came before you. They're going to define some of these best practices. They're going to define what you should do in certain situations. It's a matter of you understanding your organization's policies and following them. One thing that our book loves to talk about is as an investigator, you need to develop these procedures, and well as having your formal and informal checklists. You're not doing this off the cuff of your pants. You're going to be following the procedures set forth by the workers that came before you. Normally, the organization will already have formal policies and procedures in place for these events. They're going to have the checklists. If they don't, then you creating them on the fly is not going to happen. Normally, they will bring in experts to help develop these areas. Because these are very specific investigations that are highly specialized, they're going to take time to actually formalize. That doesn't mean that you can't do it. That just means typically this is done by people that have come before you because they've put in all the groundwork. They've done the trial and error. They figured it out through the length of time that they were there. Very rarely will organizations randomly come up with, oh, well, we need a digital forensics specialist and have nothing. If they do, that's a whole other thing. So, what do we do if the worker is terminated, for example? So the majority of the investigative work will normally deal with termination of an employee or violation of acceptable use policy. Those are the big two. But our book chose to focus on termination. Basically, the incident that will create a hostile work environment are the predominant types of cases investigated. For example, a worker viewing pornography and then they got caught. Then the investigator has to investigate, find evidence, and if they find evidence, the worker gets removed. Or, again, inappropriate emails. Both of those are going to be violations of the acceptable use policy and then abuse of corporate assets that would then cause for termination. Well, the worker that got fired is probably going to be kind of irritated and pissed off. Well, that could create a hostile work environment for the investigator. However, policies and procedures in place, this should not be allowed. Organizations need to have the appropriate policies in place to provide protection for the investigators. Oftentimes we like to forget the investigators only finding what was done. The original worker committed the crime or committed the violation in policy that caused to their termination. The investigator only verified it. So what about internet abuse investigations? Often the investigator will look at logs, addresses, artifacts on the computer, on the actual computer, and then for the appropriate tool will analyze it. Normally, we would be following the appropriate analysis techniques and procedures set forth by the organization. We'd be looking at what do we define as inappropriate. What type of web content are we looking at? Are we looking at tags or are we looking at actual content? What about a firewall or network infrastructure logs, things like that? For example, I had a case where a worker was told they were looking at adult content and then they were put on administrative leave. I was brought in to do the investigation and I found adult tags. While looking at the adult tags, I seen the website that they were associated with. It was news. The issue is the adult content tag raised the alarm. We had to go one step further to look at what content they were actually looking at, and our policy was no pornography. The adult tag was not coded very well, so we were expecting pornography, and in reality they were looking at the news, so the investigation cleared the individual. We also have email abuse investigations. Again, same thing. We go through the email, we go through the email server, we go through compliance checks on the email server, maybe even the workstation, and then we analyze it based off of the appropriate tool. Recommended steps, again, follow the corporate policies and procedures, obtain copies of the victims and the suspect's email folder, and we analyze them. For web-based email investigations, we could be using things like FTK's Internet Keyword Search or other email tools built into FTK. We examine the email headers and we follow the procedure from there. Alright, so the fun part with all of this is after we do the email, we also then have to discuss things like client privilege. One of the things is attorney-client privilege is basically rules for an attorney. Anything that is said or done between them must be kept confidential within reason. And I say within reason is because there are very specific circumstances where that privilege can be broken, but that's going to be very dependent on the situation, and there are laws and governing ordinances that cover that. That's way outside of our scope. Many attorneys like to have printouts of the data that they have recovered. You need to be able to persuade and educate many of the attorneys on how digital evidence can be viewed electronically. A big part of this is understanding while you may have a attorney within your group, understanding how to store, how to retrieve, and how to work with that digital evidence electronically is going to be important. So steps for conducting some form of ACP type case. Basically, you're going to request memorandums from the attorney directing you to start and state the scope of the investigation. Requests like a keyword list or things of interest. Again, they need to define that scope. You will initiate the investigation and the analysis from the scope that you are given. For disk examinations, make 2-bit stream images using different tools, just in case. Also, you'll be hashing them so that you can compare the hash from the original source and your cloned copies. You have to make sure that the hashed copies are identical before you proceed. Otherwise, they're not the same image. Methodology, again, you have to examine all portions of the disk. You're going to be running keyword searches. You're going to be looking at operating systems, like registry. You're going to be looking at operating system files, and you're going to be looking at binary files. Things like drawings or specific software or dynamic link library files or OS-specific files, as well as unallocated data space on the drive. For unallocated data recovery, you're going to be using tools that will remove or replace non-printable characters so we can get some form of representation. Lastly, you're going to be looking at consolidating all of the recovered data from the evidence to a folder or a subfolder or some type of structure for you to be able to analyze. Other guidance are going to be like minimize written communication with the attorney. And again, that's going to be very subjective based on the situation. Document everything. If we're doing anything protecting from a lawyer's office where it's protected data, you need to actually be able to have it labeled confidential. Things like privilege, legal communications, confidential work product, stamped on everything just to make sure. Assist the attorney and paralegal in analyzing the data the best that you can, and again, ensure that you're following all of the appropriate state and local ordinances and laws when it comes to protected data and analysis. Other important areas are going to be things like the industrial espionage and investigations. Basically, all suspected industrial espionage should be treated as criminal, so that means it's going to be on the public sector. So the staff needed is going to be an investigator, a specialist, a network specialist, and threat assessment specialist. and normally that's going to be involving with an attorney. Again, criminal investigations are done by law enforcement, not by private investigators. Guidelines when initiating the investigation is follow the appropriate state and local and federal laws, but you're also going to be looking at determining whether the investigation will involve a possible industrial espionage incident. If you are doing this privately and you do find that corporate espionage has occurred, then you must cease and then escalate it to the appropriate authority. Because again, we, a private investigator, are not allowed to handle criminal or public cases. That is understanding the scope of where we're allowed to start and what we're allowed to do. If anything we touch is involving a criminal case, we could accidentally destroy evidence in a criminal case without knowing about it. That is why we have to stop and escalate it. We do not have the legal precedent, we do not have the justification to actually do work as law enforcement. We're going to again consult with corporate attorneys and upper management before escalating it, but that is typically where that would go. If you are permitted to proceed, then you'll determine what information is needed to substantiate the allegation. You'll be looking at word lists for forensics analysis, and then you will list and collect resources for the investigation. You'll determine the goals and scope of the investigation, and then you will initiate, with approval, the investigation. For planning, we're going to be looking at all emails, all suspected employees, their emails, and other electronic devices. E-discovery or electronic discovery is going to be occurring with all of the suspected employees that might be involved in the situation. You're going to be looking for news groups or message boards that might be talking about it. You're also going to examine facilities, the physical access, and sensitive areas of the facility. You're going to determine any suspecting location in relation to the valuable assets. You're going to be looking at work habits, as well as collecting any incoming and outgoing phone logs. Lastly, you're going to be looking at conducting the case itself. So not just planning, but we're going to start doing. So gather all the personnel assigned to the investigation, brief them on the plan, make sure everyone's on board, look at the resources, gather and conduct the investigation, place surveillance systems at the appropriate locations, discreetly gather information and evidence, collect the appropriate logs, report regulatory to management and corporate attorney, review the investigation, and proceed. So with that, we have to look at interviews and interrogations. While oftentimes this is outside the general scope of a digital forensics investigator, this is part of the scope that needs to be addressed. Interviewing. Normally that's going to be conducting and collecting information from a witness or a suspect, where the interrogation is the process of trying to get a suspect to confess to some form of issue, crime, piece of information that may know. Again, understanding that our role is as a digital investigator. It's to instruct the investigator conducting the interview or the interrogation on general questions to ask. So, how can we make sure we can be a successful team for interviewing and interrogations? Basically, be patient, repeat. Again, this is going to be for the interviewer or the interrogator. Be patient, repeat, rephrase, zero in on specific facts, and be tenacious. Be relentless. So now that we understand kind of the process, we can look at data recovery and the software. Investigations are conducted typically on a lab or in a lab for recovering of data artifacts or piece of information. Well, a piece of information can also be classified as an artifact. The forensics workstation is typically a specific configured workstation that has additional storage, additional bays for quick access, More importantly, it has forensic software. So to avoid altering evidence, we're going to use a write blocker. That will mean when we get a suspect's drive, we will put it in a write blocker, and then we will copy data. The write blocker prevents data from being written to the drive. It can only be read from the drive. Normally, a workstation is going to be Windows 10 with write blocking hardware or software, acquisition and analysis tools, and USB ports, as well as plenty of space and plenty of ports. Normally, we'll have a NIC, might have FireWire, may have additional software tools for like disk editing, a text editor, as well as a graphic viewing program, and any other specialized viewing tools necessary for the investigation. So, what are our steps? When we conduct the investigation, we're gathering information. We need to have the original storage media and a copy. We need to verify that the copy and the original match. We're going to be working off of the copy. We need to have the appropriate forms, evidence custody forms, chain of custody forms, a bit streaming imaging tool for verification, a hashing tool, and we will take our verified cloned copy that has been verified via a hash, and we will work off of that. The original will be documented and then returned to a secure evidence locker, cabinet, or safe, or a secured area to ensure that the original is not tampered with at all. Again, we need to avoid damaging evidence at all costs. So gathering the evidence, we meet with the IT manager, we interview them, fill out the appropriate evidence forms, secure the evidence in a secure container, carry the evidence to the lab, following the lab's policies. So if there's more to it, the lab policy is always going to take precedent. Complete the evidence custom form, and then secure the evidence by locking the container in a secured area, again, following all of the appropriate policies and procedures. We keep talking about a cloned copy. That's called a bitstream copy, and that is a bit-for-bit copy of the original storage media, exact copy, 100% the same. It's different from a simple backup because a backup only copies known files. Backup software cannot copy deleted files, messages, or fragments. A bitstream copy can do just that. It is a 100% copy from one drive to another. We could have a bitstream image. That's where we capture the original drive, and instead of copying it to another disk, we copy it to a forensics image. So we have a virtual image at this point. So copying an image to a target disk that matches the original manufacturing size and model will also provide a bitstream copy. And again, we verify with hashes. So here the goal is the original, the image, and target disk. All of them should be identical. If we want to image and store for a later time, it'd be an image. If we want to analyze a physical disk, we'd clone the original and put that to a target disk. Again, hashing all of these should all yield the same hash result. If it doesn't, then there's another issue. So how do we acquire the image for evidence? Well, we have to preserve the original evidence always. That's why we are saying use a write blocker with our hardware or software when providing the digital image. We'll have to conduct the analysis only off of copies of the original. Again, the copy has to be verified. Normally, our acquisition tools are going to be in any common operating system. It all depends on the tool we're using, and that will dictate the vendor-specific tool that we'll be using. If we are a Linux shop, we may be using Linux digital forensics tools. If we are using Windows, we could be using Windows-specific forensics tools. It really just depends on the situation. So understand that your job as an investigator is to recover data like deleted files, file fragments, completed files. The goal is to collect evidence to analyze to get a better understanding of what has occurred. Deleted files, for example, they linger on the disk until new data is written over them. You can use FTK tools or like Autopsy to retrieve and recover deleted files, though there are other tools out there as well. So again, don't take that, oh, this is the only tool. No, Autopsy is one of many. So what about if we're collecting data off a flash drive? Well, we could start Autopsy, do a new case, do a new case number, select the appropriate working file, and then we would select the source type, select an image file, and from there we would use the configuration to ingest data. That does no good unless you've used Autopsy to begin with, but I mean there are steps for analyzing based off of the tool you're doing. And again, part of this is for us to walk through the process so that when we get later in some of the other chapters, we can talk about actually what to do. So again, in Autopsy, if we want to display the contents, we could play with the views. We can filter off of file types, extensions, or the documents or tags. That's how we're going to be analyzing that data. The data analysis is typically the most time-consuming portion of this. In Autopsy, here is the new case. We would define the new case. We would type the base directory. We can say what type of user is going to be using this, either a single user or multi-user, and then we would say where is it stored at. With Autopsy, you can do the searching for keywords, we can export data, we can search for extensions, but Autopsy is a pretty flexible forensics analysis tool. You can look for a non-printable binary data in the content viewer as well. You can search for keyword lists. You can look at data within a file type. So if we're looking at a text document or a configuration file, we can dig into that. All of that is going to be done through Autopsy, at least through our text. There are other tools out there that are not Autopsy, but Autopsy is one of the more common. And again, we could look at the hex string version of them. We could look at the metadata or the string data of them. So let's talk about completing the case. Basically, when you do a case, it needs to be repeatable. It needs to be documented in such a way that you can provide this to the opposition and they can follow the same thing that you've done and get the same results. Now, the methodology should be of sound mind, meaning if you do something really far-fetched and they don't do that because that's not a common practice, then clearly that's not repeatable. So everything that you do should be able to be repeatable within good sense. Everything needs to be written. You want to be as detailed as possible. Versions, steps by steps. Who found what, you or the software? You want to answer the 6 W's. Who, what, when, where, why, and how. You want to explain the process. You do not want to just use a generated report. You want the report and you want to add more. You want to explain step by step what you did. And you want to support it with facts. The end portion is to critique the case. Ask yourself, how can you improve? What can you expect for the results? Where can the opposition target your case? Where is it weak? Were there any new problems, any new issues? All of that should be there, should be reflected on, and improved upon. Alright, so that makes the end of the chapter. We covered the digital forensics process, the investigation process, understanding public and private sectors. We looked at the systematic approach for investigation. We looked at criminal and corporate policy violations and how they go to court. We looked at contingencies and problem finding that might occur. We looked at chain of custody. We looked at internet abuse investigations. We looked at attorney-client privileges. We kind of wrapped it up with bitstream copies and documentation. That is all for this chapter. Alright, now that we've wrapped up some of the material for this chapter, are there any questions? There's a lot of different material covered, so again, the key thing is, as you're going through the material, whether it be the reading, whether it be the videos, ask questions, write questions down. The more that you can engage your brain in this material, the better you are at retaining the information. So again, questions, please feel free to reach out and we will go from there. Thank you, and I look forward to working with you throughout the remainder of these modules.